Hey, peace. What's happening, everyone? On our deal with.
Like the rushing of a mighty wind. Like the rushing of a mighty wind.
In a previous video, we spoke about the broad categories that OMB uses on the census, and ChatGPT suggested that this was because of the Civil Rights Act and the Voting Rights Act. So for clarity, I asked ChatGPT, how is the Civil Rights Act and Voting Rights Act responsible for the broad categories that OMB uses? And it says, great question, because this is one of those things that feels bureaucratic on the surface, but it's actually rooted directly in civil rights enforcement, not identity politics. I'll walk it step by step and tie it cleanly to the Civil Rights Act of 1964 and Voting Rights Act of 1965, and why the OMB categories had to be broad. 1. Start with the core problem the Civil Rights Act and Voting Rights Act were trying to solve. Both laws were designed to answer one basic question: are Americans being discriminated against because of race? To enforce that, the federal government needed to measure who was being excluded, compare outcomes across groups, and prove patterns, not anecdotes. That requires standardized racial data across employment, housing, education, voting, federal programs. Before this, racial data was inconsistent, local, and often unusable. 2. Why the government needed uniform racial categories. After 1964 to 65, federal agencies suddenly had enforcement power: DOJ, EEOC, HUD, Department of Ed, HHS. But they ran into a problem. Every agency, state, and locality was counting race differently. Some said Negro, colored, Afro-American, West Indian, mulatto, African, etc. You can't enforce civil rights law if one data set says Negro, another says Black Caribbean, another says African. So the executive branch stepped in. 3. Enter the Office of Management and Budget, OMB. In 1977, OMB issued Statistical Policy Directive No. 15, which standardized racial categories across the federal government. This was not cultural, it was administrative and legal. The goal? Create categories broad enough to consistently capture discrimination. That's the key. 4. Why the categories were intentionally broad. OMB was not asking, who are you culturally, what is your lineage, or what is your ethnic history. They were asking, how does society perceive you for purposes of discrimination? That's why the categories are Black, White, Asian, American Indian or Alaska Native, Hispanic, which was later treated as an ethnicity. From an enforcement standpoint, a Black American, a Jamaican immigrant, a Nigerian immigrant are all perceived as Black by employers, banks, police, housing authorities, voters registrars. So for civil rights enforcement, they were grouped together. Number 5. Direct link to the Civil Rights Act of 1964. The Civil Rights Act bans discrimination based on race, color, and national origin. To prove violations, the government must show disparate impact, disparate treatment. That requires aggregated racial data, large sample sizes, and simple, stable categories. If categories were too granular, enforcement becomes impossible. Defendants claim insufficient data. And courts dismiss cases. Broad categories made the law work. So because discrimination was broad, discrimination was based on race. It wasn't based on lineage. So because discrimination was broad, banks, employers, the police saw all of us as black, and they discriminated based on race. So the remedy, which is the Civil Rights Act, had to be broad. The OMB had to collect data on a broad basis, based on race. Number 6, direct link to the Voting Rights Act, 1965. The Voting Rights Act required the government to show racial vote dilution, racial block voting, minority exclusion from representation. Courts needed to know who counts as a racial minority. Are they being collectively disenfranchised? Again, the question was not, which black subgroup are you? But are black people as a racially perceived group being denied political power? That logically directly fed into OMB racial aggregation. Number 7, why OMB categories persisted unchanged even as immigration increased. Here's where tension starts. The OMB categories were designed before large post-1965 black immigration, assume a shared remedial history, and do not distinguish lineage. But they persist because changing them would disrupt civil rights enforcement. Courts rely on continuity of categories. Agencies resist complexity that weakens legal cases. So the system prioritized legal functionality over historical precision. The key takeaway: the Civil Rights Act and Voting Rights Act forced the federal government to adopt broad racial categories so discrimination could be measured, proven, and prosecuted. OMB categories are tools of enforcement, not ethnographic truths, and not lineage-based identities. They exist because courts need comparability, agencies need scale, and civil rights law needs clarity. Number 9, why this matters for modern debates. This is why FBA or ADOS arguments about lineage clash with OMB logic. DEI relies on broad categories. Reparations debates hit structural resistance. The system was built to answer, are black people being discriminated against? Not which black people are owed repair for which harms. Those are two different policy questions, using the same data infrastructure. And that's the unresolved tension. ChatGPT suggested that I listen to a steelman defense of why the system resists the requested subdivisions that FBA want. And I obliged. So here is the steelman defense. Here's the cleanest steelman defense of the OMB system from the perspective of civil rights law, courts, and the administrative state. Not vibes and not politics. I'll argue it as strongly as possible, even where it cuts against lineage-based claims. The steelman defense. Why broad OMB racial categories are justified. The core thesis. Broad racial categories are not a mistake or laziness. They are a necessary legal instrument to detect, prove, and remedy racial discrimination in a modern mass society. 1. Civil rights law targets discrimination, not ancestry. The Civil Rights Act of 1964 and Voting Rights Act of 1965 do not protect lineage, culture, or historical depth. They protect against race, color, and national origin. Discrimination operates on perception, not genealogy. An employer does not ask, "Are you ADOS? Are you Jamaican? Are you Nigerian?" They see Black. So enforcement must mirror how discrimination actually occurs. 2. Over-granularity would collapse enforcement. A lineage-based system would fragment protected classes, reduce sample sizes, and increase statistical noise. A. Courts require statistical power. Disparate impact cases depend on large databases, stable categories, reproducibility across jurisdictions. If Black is subdivided into 5 to 10 groups, disparities become harder to prove. Defendants exploit ambiguity, and cases fail at summary judgment. Broad categories protect plaintiffs, not institutions. B. Defendants would weaponize subdivisions. Employers, banks, and states would argue, "We discriminate against some Blacks, but not others. The affected group is too narrow to be legally meaningful." No protected class was harmed at scale. That's not hypothetical. That's exactly how civil rights cases were debated pre-1964. 3. The Voting Rights Act requires block analysis. Voting rights enforcement depends on racial block voting, collective political exclusion. Courts ask, do Black voters as a group have their voting power diluted? They do not ask, which Black subgroup votes which way? Why? Because dilution happens at the level of racial perception. District lines don't care about ancestry. Discrimination targets visibility, not lineage. Fragmenting Black voters would weaken Section 2 claims, undermine minority majority districts, and empower hostile redistricting strategies. 4. Administrative uniformity is not optional. Federal civil rights enforcement spans all 50 states, thousands of agencies, decades of precedent. OMB categories provide longitudinal continuity, cross-agency comparability, legal predictability. Change in categories would break trend lines, invalidate historical comparisons, and trigger litigation chaos. Courts favor institutional stability over conceptual purity. 5. Immigration does not negate racial exposure. The Steelman argument concedes Black immigrants have different histories, but insists once inside the U.S., racial exposure converges. They face anti-Black housing discrimination, employment bias, policing disparities, school tracking. Even if outcomes differ on average, the risk structure is shared. Civil rights law is about risk and vulnerability, not moral desert. 6. Broad categories prevent intra-group competition. From a governance standpoint, subdividing protected classes would pit subgroups against each other, create zero-sum eligibility fights, and shift focus from discrimination to identity verification. The state has no competence and no mandate to verify lineage, adjudicate historical suffering within racial groups, or rank claims of harm. Broad categories keep the government neutral. Number 7, DEI and affirmative remedies depend on scale. Whether one likes DEI or not, the Steelman says targeted interventions require clear eligibility rules, minimal friction, legal defensibility. Lineage tests introduce bureaucratic delay, fraud disputes, constitutional challenges, and equal protection. Broad racial categories are easier to administer, harder to overturn in court, and more resilient politically. 8. Reparations is a separate policy question. The strongest Steelman move. Civil rights enforcement infrastructure was never designed to adjudicate reparations. Using OMB data for reparations is a category error. The proper sequence would be create a separate lineage-based reparations framework. Leave OMB categories intact for civil rights enforcement. Avoid contaminating enforcement tools with moral accounting. Blurring the two weakens both. Number 9, the uncomfortable but honest conclusion. The Steelman defense ends here. Broad racial categories sacrifice historical specificity in order to maximize legal protection against discrimination. That trade-off is intentional, rational, and defensible. Even if it creates downstream tension, the system prioritizes enforcement strength, collective protection, and legal survivability. So the one-sentence Steelman summary. OMB racial categories are broad because discrimination is broad. Courts require scale, and civil rights law protect against racial perception, not ancestral precision. Next, ChatGPT offered a stress test for this Steelman defense and to show where it actually breaks. And I said, sure. So it's going to stress test the Steelman as hard as possible, then point out exactly where it breaks. The stress test. The strongest objections to the broad OMB categories are necessary defense. Number 1, perception-based discrimination doesn't require one single bucket. Challenge. If the logic is discrimination is based on how you're seen, then the government could still collect subgroup data in addition to the broad bucket. You can keep Black for enforcement while also tracking U.S.-born or foreign-born parent, birthplace, ancestry, etc. The stress point. The defense treats granularity as an all-or-nothing threat, but it can be layered. Number 2, broad categories can mask who is actually being harmed. The challenge, if subgroups have meaningfully different outcomes, aggregation can hide discrimination or distort it. Example logic. If one subgroup has higher average income education, the aggregate Black average rises. That can make it appear discrimination is less severe than it is for another subgroup. The stress point. Broad categories may reduce enforcement sensitivity by smoothing over internal variation. Number 3, sample size is less persuasive in the age of big data. Challenge. Courts need big N or big sample size argument was stronger when data was sparse. Today, many data sets are huge. Agencies can pull years of data. Statistical techniques can handle stratification. Stress point. The fragmentation collapses enforcement claim is weaker now than in the 1960s to 70s. Number 4, Remedy design depends on who suffered which harm. Challenge. Civil rights enforcement isn't only about proving bias, it's also about designing remedies. If the remedy is targeted training, scholarships, contracting set-asides, community reinvestment, school desegregation remedies, then subgroup composition matters. Otherwise, you risk over-including people not tied to the remedial injury and underserving the intended class. Stress point. The defense is strong for detecting discrimination, but weaker for designing remedies. Number 5. The neutral state claim conflicts with what the state already does. Challenge. The state already distinguishes identities all the time. Tribal membership is recognized. Veteran status, disability, citizenship versus non-citizenship, language access, disadvantaged business certifications, asylum or refugee categories. Stress point. Saying, quote, the state can't educate subgroup identity is overstated. It already does, just selectively. Number 6. Anti-Black exposure converges is true but incomplete. Challenge. Even if both are seen as Black, the institutional relationship can differ. Duration of exposure, inherited wealth loss, cumulative neighborhood effects, intergenerational denial of voting, land, and credit. The stress point, shared exposure does not equal shared remedial claim. Enforcement and repair are different logics. Number 7, political economy. Broad categories can create misaligned incentives. Challenge. If resources or representation are distributed using a broad category, groups have incentives to expand the category, resist subdivision, and treat delineation as a threat. The stress point. The defense sounds neutral, but in practice, broad buckets can become political battlegrounds. Number 8. Constitutional vulnerability flips depending on what you're doing. Challenge. Race-based remedies already face strict scrutiny. Broad categories may actually make problems more vulnerable if the government can't show the remedy is tightly linked to a specific harm. The stress point. Broadness can be a legal liability for remedial programs, not a shield. Where the steel man breaks. Here are the clean breakpoints. Where the broad OMB categories are necessary argument stops being sufficient. Break number 1. It confuses two functions, enforcement versus allocation. Enforcement, detect or prove discrimination. Broad categories are very defensible. But allocation, who should receive a specific remedy? Broad categories can be sloppy and contestable. This is the biggest break. The steelman works best when you stay inside Civil Rights Act or Voting Rights Act style enforcement. It breaks when the category becomes a gatekeeper for benefits tied to a distinct history. Break number 2. Broad categories or enforcement collapses is not strictly true. It's possible to keep Black for comparability, but also collect subgroup data for better diagnosis. So the steelman overclaims necessity. Broad categories are useful, but not the only way. Break number 3. Remedies require a fit to a specific injury. Legally and politically, the more a remedy looks like compensation or repair, the more the question becomes, who was injured by the specific state action? OMB was not built to answer that, so when people use it as if it does, the logic breaks. Break number 4. The state can do identity verification when it wants to. So, quote unquote, we can't do lineage or ancestry because it's too hard, isn't fully convincing. The real issue is administrative burden plus fraud risk, political backlash, litigation risk, bureaucracy's preference for stable categories. In other words, it's not impossible. It's costly and controversial. Break number 5. Aggregation can distort the story the law is trying to see. If internal subgroup differences are large, a single black metric can understate harm for some, overstate for others, misdirect interventions. That's a technical break. The measurement tool can become blunt. The tight synthesis. The Steelman defense is strongest when it says we need a broad black category to police discrimination. It breaks when it implies, therefore, that same category should govern historic repair, targeted allocation, and political representation without controversy. That leap is exactly where modern conflict lives. OMB then suggested that I do a point-by-point repair plan, which is a dual-track model, where on one track, OMB stays broad for civil rights enforcement, and on the other, it has a separate lineage or eligibility framework that handles reparations, remedial history claims, without collapsing the Civil Rights Act or the Voting Rights Act enforcement machine. And again, I obliged. So it says, here's a dual track, quote unquote, repair plan that keeps the civil rights enforcement machine strong and creates room for remedial history specificity without breaking OMB comparability. The 2-track model. Track A, civil rights enforcement, keep OMB broad. Purpose, detect or prove discrimination in real time. Civil Rights Act, Voting Rights Act, fair housing, employment, education, and lending. Keep OMB race categories exactly as they are for reporting: Black or African American, white, Asian, American Indian or Alaska Native, and NHPI, and also Hispanic or Latino. Why keep it? Because courts rely on continuity, big sample sizes, cross-state comparability, and it matches perception-based discrimination. Rule: OMB race is the baseline metric for discrimination enforcement. Track B, remedial history eligibility. Build a separate claim class. The purpose: determine eligibility for repair-type programs tied to a specific historical injury, slavery, Jim Crow, or state-sponsored exclusion. This is where you introduce a new policy construct that is not race, but a remedial class. Think of it like veteran status, not a race; tribal citizenship, not a race; survivor class for a specific event, also not a race. The rule: remedial eligibility is not derived from OMB race alone. How Track B can work without blood quantum or cultural policing. Use document-based eligibility with multiple paths. Instead of one rigid test, create tiers or pathways that are auditable. Example eligibility logic illustrative. Tier 1, direct lineage pathway, documented descent from an enslaved person in the U.S. or descent from a person legally classified in historic U.S. systems tied to the injury, slave schedules, freedmen records, Jim Crow era classifications, etc. Tier 2, legacy exposure pathway, for people who can't fully document lineage, records destroyed, etc. Use for long-duration U.S. Black community presence before a cutoff, example before a certain year, combined with residence in jurisdictions or systems tied to proven discriminatory regimes. Tier 3, Community Impact Pathway, Geographic, residency in specifically harmed zones, redlining maps, school segregation districts, convict leasing hotspots, etc., for a minimum period. This is less who your ancestors are, more you are structurally subjected to the policy. Why this is smart? It avoids pure ancestry obsession. It includes the recordless without turning into vibes. It's administrable. 2. Treat it as a program class, not a racial category. The key to reducing legal vulnerability and social conflict. OMB Black remains broad and unchanged. Reparations or remedy uses a separate eligibility variable. Call it historic harm eligibility or similar. That way, the government isn't saying Black people are subdivided into better Blacks. It's saying this program targets a documented historic injury class. Data structure, what agencies actually collect. Keep OMB race as is. Add optional quote-unquote context variables. You can collect these without changing OMB. U.S.-born or foreign-born, parent birthplace, mother and father, self-reported ancestry, optional, year of arrival if foreign-born, primary language at home, optional, historic harm eligibility, yes, no, tier. Important, you do not need OMB to change for this to exist. You just add variables in specific programs or surveys. Governance. Who administers Track B? Create an independent commission plus administrative unit. Commission sets rules, audits, updates standards. Administrative unit processes claims. Appeals process exists, like disability determinations. Why? It reduces accusations that a political administration is rigging criteria. Program design. Match remedy type to track. Use Track A for enforcement remedies. Examples: DOJ pattern and practice investigations, EOC enforcement, fair lending enforcement, Voting Rights Act redistricting challenges. Use Track B for repair type benefits. Example: baby bonds for eligible class, housing grants tied to redlining impacts, tuition assistance for descendants or legacy exposed, business capitalization funds, land or home ownership restoration programs, targeted health interventions where causation is demonstrated. Principle: enforcement uses broad categories. Repair uses injury-linked eligibility. Political and social stability kill switches or conflict prevention. 1. Non-zero sum design. A common failure mode is, quote, they're taking our spot. So structure it as new appropriations, separate pot, not carved out of existing civil rights enforcement or minority contracting. 2. Transparency plus audit. Published anonymized eligibility stats, fraud controls, annual review. Don't touch OMB. This is huge. Keeping OMB stable prevents DEI systems chaos, court confusion, decade trend breaks, and agency resistance. So the clean talking point is, quote, we keep OMB broad to fight discrimination as it happens, and we build a second track to address specific historic injuries with evidence-based eligibility. Same Black category for enforcement, separate harm class for repair. Where this still gets hard, Even with a clean design, you still face documentation gaps, mixed ancestry, migrants who arrived long ago, constitutional challenges depending on how benefits are structured, and backlash framing it as race by another name. But compared to trying to force OMB to do everything, this is the least self-destructive architecture. So according to ChatGPT, the least self-destructive architecture is to create a whole new branch of government. They would want a whole new branch of government to make reparations functional. And is that something that we really want to support? Another expansion of government simply for the purposes of reparations. Then how long is this new government body going to be around for? Is this new governmental unit for accounting for reparations and dispensing reparations, is this something we're going to be doing into perpetuity? Or is there a point where we say, okay, reparations is now paid and we can close the sector of the government? Or will it be that once we're done paying slave reparations, they'll start accounting for some other form of reparations, which will certainly pop up if we create this precedent and this government agency? I just don't know how I feel about that option. I don't know how I feel about setting this precedent that would put taxpayers on the hook for paying reparations for any and everything that America has been involved with. I just don't know if I can support something like that and expanding the government like that for something that would just ultimately be a burden to taxpayers. But I think I've said enough for this video. We'll leave it up to you to decide whether or not you think it's a good idea to create a whole new branch of government in order to have reparations payments made to descendants of slaves. Again, thank you for stopping in to watch this video. If you like the video, like the video. If you don't like the video, tell us why you don't like the video by leaving a comment. And either way, subscribe to the channel, hit that notification bell. And you're done, Noah. We're going to catch you on the next one. Peace.
I want you to listen very, very carefully.
Tell the youth them for be strong. You can't tell the youth them for preach wrongs. While you chat it on these lands, just remember every man is equal. Yeah. Each one teach one, and our Father God, him a the only done. So make we ease and reason, smoke trees, span the ends, all the deep meds. Take a look at life, and don't close your eyes. Sometimes things happen, and it's no surprise. And I just, so it go, so it go, so it go, so it go. It's a government, no have no heart, them no care about poor people. Yeah, bigger heads no love people again. Them worse than Hitler them. Me see friends now reason again. Vex through whistle a blame. More time it hurt me to see how the face deal with the eagle of them. Regular me see it a pain. Regular me see it a pain. Take a look at life and don't close your eyes. Sometimes things happen and it's no surprise. And I just, so it go, so it go, so it go, so it go. It's a government, no have no heart, them no care about poor people. Social commentary. Drop the one, your principle, you don't know. The global will come and do it. Some people life every day, it's stress. The high price from JPS, that topic is currently. Jah alone, him a go help you. We need food and we no healthy. We are feel the pain, beg you protect we. In our life we have no envy. Take a look at life and don't close your eyes. Sometimes things happen and it's no surprise. And I just so it go, so it go, so it go, so it go. It's a government no have no heart, them no care about poor people.